Thanks for joining us for Probate Law from A to Z. Hi, I'm probate attorney Dan Scott, and I help families work through the probate process in a stress-free environment to provide certainty and closure when they've lost a loved one. Today in our A to Z series, we're not going to cover A to Z. We're only going to cover the letter C. Today, the letter C, we're going to talk about creditors. And you say, Dan, why is it that you want to spend any time talking about creditors? Everybody knows that a creditor is somebody you owe money to, either an individual or an entity. But you see, what I'm talking about with you today is the creditor of an estate. Now, that is a unique category of people or entities. A creditor of an estate is a creditor, someone who's owed money, an individual or an entity, who actually files a claim in the probate case. Now, some creditors don't file claims. For example, a mortgage company often does not file a claim. If you don't file a claim in the probate case within the proper time allowed, you don't have a claim in the case. Have you seen the notices that run in the paper that say John Smith died and his estate has been opened in Sevierville County, Tennessee? You've got 4 months to file your claim. The reason for that is because if you don't file your claim within that 4 months, you likely will lose your claim. And what that means is you will not be able to get paid out of the estate. The personal representative could really want you to get paid, but if there's no claim filed, the personal representative cannot pay you. In a situation with a mortgage company, the mortgage company says, look, I'm not going to file a claim because I've got a deed of trust on real estate. And so they're going to realize their collateral, that is foreclose the real estate, and collect their money on the real estate. Well, what happens if there's not enough money when they sell the real property? They sell the house, they foreclose on it. What happens? Well, here's what happens. They cannot go against the estate, that is make a claim inside the estate for the amount of money that's left, assuming that they wait until after the time period for the running of claims is filed, or it occurs, the time period occurs. So be careful about that. If you're owed money in an estate, what I recommend to my clients whenever a creditor comes to me and they ask me to help them with an estate, I say, look, let's file the claim. Let's file it. I want to file it now because I don't want you to let your time run. We can always make a deal with the personal representative to adjust the amount of the claim, to provide that we're going to be paid from the collateral. We can make a deal, but if you do not file your claim in an estate, even though you're owed money, you are not a creditor of that estate. What does it mean to be a creditor of the estate? It means that you're going to get paid before the heirs get paid, before the beneficiaries under a properly probated will get paid. So you're going to get paid on the front end. The only people above you, if you're a creditor, is the administrative costs of the estate. And so you want to get that claim filed. But if you don't file a claim, you're not a creditor. So that's our C for today. When I watch us, because we're coming up with the letter D, and you're going to be excited to hear what D is in the probate law from A to Z. Thanks for watching. Hope this was helpful for you. Thanks for watching our probate law from A to Z. If you found this information helpful, would you go ahead and subscribe to our channel? On YouTube, hit the bell, jam it, because I want to be able to send you notices when we do new videos.